Okay, hi everyone. Thank you so much for being here. It is wonderful to see you all. I'm Erin O'Neill, the director of the Capital Center for Law and Policy and our capital lawyering concentration here at McGeorge. And we are hosting this event this evening to discuss the ramifications of Proposition 50, the special election measure that's going to be on the ballot in just a few weeks. That involves.
Maybe we should start, because there's a full screen coming in now.
Erin,
The stream.
do you mind clicking on the screen, hit OK?
Hit okay?
Yeah,
With the-
just to get rid of that little banner that
Yeah.
popped up. There we go.
Yeah, are we good now?
Yeah.
Okay, all right. Hey, Teddy. Hi, everyone. Hey, Delmar.
Yeah.
You want me to start again?
No, I'm just, you don't
Okay.
have to start again.
Welcome. I think this will be a very fruitful and interesting discussion. Obviously, this is a hot ticket item on the ballot. There is a lot of political and policy and governmental structure issues that are raised by this proposition. And we have two experts here to give us a nonpartisan look at the measure as we all get ready to vote. So we're excited to welcome Professor Moylan, Professor Heidorn, and they're just going to take it away from here and be sure to ask questions. I think this is a great opportunity to kind of find out more than we're able to glean from just the ballot sort of propaganda materials that we see. We can actually get our questions answered here. So thank you for being here and joining us.
Thank you very much, Professor O'Neill, and thank you all for being here online and in person. I'm Mary-Beth Moylan. I think most of the people in the room know who I am, but I have been a professor at McGeorge for 25 years. I teach a lot of different classes, including the California Initiative Seminar, which I teach every other year in election years, and we focus on the ballot propositions. Students in my seminar do an objective and neutral analysis of each of the statewide ballot propositions, and we produce the reports on those propositions as the California Initiative Review. We also do public forums. For those of you who are here and will still be here next year, the California Initiative seminar will be happening in the fall of 2026, and you'll have an opportunity to take that elective class. Normally, the students would be doing the objective and neutral analyses of Proposition 50, but because we didn't know there would be an election this year, I'm not teaching the class this year. So Professor Heidorn has graciously agreed to participate with me in doing this brief talk about Proposition 50, both what it is, what it does, how we got here. We're really going to start with the how we got here. What is the legal landscape that brings us to Proposition 50? What is the political landscape that brings us here? And so Professor Heidorn is going to introduce himself and also take us through kind of a little bit of the history. He is an expert in redistricting. This is, he's a public policy professor here now, but before that, he worked for Common Cause. He's been involved in the creation of Prop 11, which was the redistricting commission. He is extremely knowledgeable. We're very lucky to have him. He's going to take us through the background and some of the cases, some of the legal cases that have informed where we are right now. And I'm going to talk about a little bit about California districting and the way that it's been done in the last few years. And then I'm going to go into this proposition and what it would do and what the consequences of it would be. We are taking a nonpartisan approach. We'll go over what the pro and the con arguments are. And then our goal is to leave a lot of time for your questions and for a real discussion about it. So we're going to race through some background information that will help you to understand where we are, why we're here, and then we'll talk about what we should all do next, but we won't tell you what to do next. That's up to you. Okay, over to you, Professor.
Thank you, Professor Moylan. Thank you, Professor O'Neill and Capital Center, and mostly thank you to all of you for coming and joining us. So as stated, my name is Nicolas Heidorn. I'm a first-year professor here, although I'd adjuncted a few years back as well. But my background is in elections, and I'm not new to redistricting. I've done a lot of work in the legislature on redistricting, and as was mentioned, formerly worked for Common Cause. Common Cause is one of the lead organizations pushing the creation of an independent commission. So some of the background history I'm going to tell you about, a little bit personal for me, and I want you to have that in mind, that this presentation is going to be hopefully neutral. All right, so first, let's take a big step back and talk a little bit about redistricting and why we even have it. So redistricting is the process of redrawing election district boundaries so that they remain equal in population. Now, Prop 50 is relating to Congress, but it's important to also remember redistricting happens at all levels of government. Wherever you have election districts, they will have to go through the process of redistricting. So here's the map of our current congressional districts. We have 52 congressional districts. But if you live in the city of Sacramento, then you also live in a council district. You've got council districts, just like Congress has to go through redistricting, council districts have to go through redistricting as well. In this case, Prop 50 is only relating to how we draw those congressional districts. So Supreme Court has said anyone who has districts has to do redistricting. The Supreme Court has also said redistricting has to happen at least every 10 years. That's what we call the normal redistricting cycle, where redistricting can actually happen more frequently. When that happens, it's called a mid-cycle redistricting, because you're doing it more frequently than is constitutionally required. So we know what redistricting is, but why do we do it? The main thing, of course, is to make sure we have an equal population. People in the district can die, people can even be bored, they can move into another district, people can move into that district. New housing developments can be built, bringing in more people. Essentially, over the space of about 10 years, certainly 20, 30 years, you can have big changes in population between districts. But the reason fundamentally that we want to account for those population changes and re-equalize the districts and population goes to this concept, one person, one vote. Just curious show of hands, how many people have heard that phrase, one person? Good, nearly all of you. So this has become kind of a central component of our Constitution and our democratic order in the United States. It came about through a series of cases in the 1960s, kind of in the heart of the Warren Court. What it basically said is when it comes to voting, we want everyone to have about equal power in the voting process. If these districts got too out of whack, people who were representing a smaller number of people that had a representative would effectively have more power to have their voice heard in Congress. So let me actually give you an example. Let's take LA. LA has 10 million people. Some of the counties in California have only a few thousand people, right? So imagine for a moment you have LA and then our state senate legislature. We have 40 state senators. Imagine LA got one state senator and you took 3 of our smallest counties, 30,000 people, and they got one state senator. What would that mean? I mean, the voice of 30,000 people would have equal weight to 10 million people. If you extrapolated that out and said, we're going to try and get every county a state senator. I mean, the rural areas would be massively overrepresented, and the urban areas would have barely any representation at all. It would be 3/4 rural representatives, only a few urban. Well, you actually don't have to imagine that because that's what we used to have. Up until the 1960s, LA County indeed only got one representative compared to those small counties that were listed. And so I got struck down, even though, so at the time, LA had 450 times less voting power than the rural areas. And that's what was struck down with that one person vote standard. But there's another kind of broader idea of why we redistrict. And this one is a little bit more intangible. And you're going to see this becomes a legal problem in a second. And that's this idea that redistricting is supposed to create fair and effective representation for all citizens and communities. So imagine for a second, we could elect everyone at large, right? We could have no districts. In fact, a lot of city governments have no districts. But part of what you lose is that you wouldn't get representation from all areas of the state if you did that. People who get elected at large tend to focus on where the votes are, who the wealthy are. It's part of the reason why we have districts, is to ensure everyone has a voice in democracy, including rural areas, low-income areas, etc. But the reason that districts are effective is because you're trying to group together people who have kind of similar interests. If you want everyone to have a voice in the democratic process, that means people face similar issues, rural issues, urban issues. They each need to have a chance to elect a representative. So there's this concept that we want the districts to represent people who have similar interests so that they'll have a voice and representation in the legislative body. Now, redistricting has actually gone on before even the founding. Even some of the colonies did redistricting. As long as we've had redistricting, we've had this other thing called gerrymandering. How many of you have heard of gerrymandering? All right. So gerrymandering is when you manipulate districts to try and give an unfair advantage to a political party, to a demographic, or to a group. And this dates back to the founding as well. To give you just one example, in 1812, in Massachusetts, the governor of Massachusetts drew these twisted lines going through all these counties to make sure his party would win the election. They called it at the time, this is Governor Gary's salamander. And thus the Gary Mander, what we now call the gerrymander, was formed. The difference is now gerrymandering can be much more powerful. And so we're going to go into two techniques of how gerrymandering works, just to illustrate the power this can have on our representative process. So the two tools in the gerrymander's toolkit, cracking and packing. Cracking is when you try and over-concentrate. Cracking is when you try and split up people's voters so they can't win a single district. It's called diluting their vote. Packing, on the other hand, is when you over-concentrate them so that they can win as few seats as possible. Let's just show what that looks like. Imagine you had a community that's about 40% purple, 40% or 60% green. This would be like political parties. You might assume on the natural, if that's the split, that purple's going to win about 40% of the seats, green's going to win about 60% of the seats. But if green is drawing the line, an incentive to crack purple's voters. That means is they're going to draw the districts so that purple's voters are split up, so they can't win in any of the districts. So even though green is just 60% of the voters, they win 100% of the seats. Purple's drawing the line, they're going to use tactic of packing. They're going to put all the green voters into as few districts as possible so they can win the remainder. So even though purple is a minority, they'll effectively control the legislature through having packed their opponents. What this shows you is the power of drawing those lines. It's so powerful, it can change the actual outcome, change what bills can get passed, change whole factors of representation. And today it's even more powerful because we have precise data. We know exactly at the precinct level, not a block, how everyone voted, what party they voted for. We know everyone's party registration. We know the demographics due to census data. So what we can do with these tools makes even more precise than ever would have been possible, even say 20 to 30 years ago. So Thomas Hofeller here is now deceased, but for decades he was the guru of Republican redistricting. He has this great quote where he says, "I define redistricting as the only legalized form of vote stealing left in the United States today." So if this is vote stealing, will the courts save us? This is law school. Let's talk a little bit about the courts. At first, it seemed like yes, there are a bunch of cases in the 70s and the 80s where the courts never struck down a gerrymander, but they all agreed, look, under the Constitution, this has to be kind of a problem. They're disenfranchising people based on who they vote for. And this kind of came to a head in a case called Bandemer, Davis versus Bandemer in 1983, where they decided Indiana didn't do enough of a partisan gerrymander to be struck down, but a majority of the justices agreed you can't get away with this at a certain level. Partisan gerrymandering has to be a violation of the Equal Protection Clause. But the problem was they couldn't agree. Some of them said you have to show intent, maybe you use statistical modeling. Others said, well, you're going to need to have like practices, show the procedures are off. The majority couldn't agree on what the test should be. And the concurrence in this case, because they agreed that the map shouldn't be struck down. But essentially they said, courts can't get involved in this. And the reason goes back to that initial point. It's very hard to say what is a good district and what is a bad district. So what the concurrence said, what O'Connor said is, you're asking the courts to do a political decision. Legislatures draw districts. The courts have no judicially manageable standard for determining what is a good district and what is a bad district. So there's this doctrine in constitutional law called the political question. When something is fundamentally a political question, it belongs to the legislative branch, not the courts. So even if in the abstract there's a constitutional violation, the courts can't give a remedy. So that's what the concurrence said. But you'll see right now, you had six votes in favor of it being a violation that could be remedied. The problem would become that over the next decade or so, the courts tried, failed over and over again to come up with a standard. In Heath versus Jubileer, you just had this judgment by Kennedy, swing vote, saying he still thought it was justiciable, but he acknowledged over 20 years we hadn't come up with a standard. Maybe if we give it more time, we'll come up with one, a standard that the judiciary could implement. So it isn't just judges deciding their view what the best district is. Fortunately, the end of the story is Rucho versus Common Cause. There's a horrible gerrymander in North Carolina where they basically admitted that they were drawing the lines to disenfranchise Democrats. But finally, the court said, we've now given this 40 years, we couldn't come up with a standard. So partisan gerrymandering is going to be non-justiciable. It's a political question. The dissent, Kagan said this is going to flood the doors open to even more aggressive partisan gerrymanders than before, because there was always this risk that your maps could be struck down, and now the gates have been swung wide open. And she said this is going to have incalculable harm for our democracy. I think at least the door swinging open is proven correct, because now we're seeing aggressive gerrymanders everywhere, knowing that the courts are not going to be barred to it. So the answer is the courts won't say this. Another more recent case, Alexander versus South Carolina, I'll just mention in passing, this relates to racially discriminatory gerrymandering, which is justiciable. There's a case coming up relating to this, but the court recently held that it's not justiciable even if there is what seems to be racial discrimination, if in fact the people drawing the lines are trying to do partisan discrimination, even if you have people of one race voting for one party. So it seems like it's racial discrimination. If the intent was actually to discriminate based on party, then it's non-justiciable. So this too is going to create a lot of issues, because now people can say they need to disenfranchise Black people. I was just trying to disenfranchise Democrats, then it could be upheld. Justice Alito authored that opinion, making clear that we start with the presumption of good faith as a legislature. I'll now just rush us through. So we talked about the legal landscape. We talked about the background redistricting. The last piece of background that I want to walk you through is just in California. So how did we get to where we're at in California? California is no exception. We had pretty extreme gerrymandering in California that was earlier in our history. Prior to 2010, our legislature drew the lines for the state assembly, Congress, state senate. Very typical in those states. That's the way it works. In 1980, we had an extreme Democratic partisan gerrymandering, where the Democrats had something like 4 to 5 congressional seats. You can see an example of how these lines squiggle around with little tentacles to grab little pockets of voters. And the author of that plan was the very Phil Burton, a very famous Democratic politician. And when asked about it by the press, he said, "This is my contribution to modern art. These maps, this contribution." In 1990, the legislature was Democratic, but the Republican was governor. They deadlocked, so the courts had to draw them out. 1990s ended up being one of the most competitive times in California electoral history. In fact, the legislature briefly switched to Republican in the assembly. That's how competitive the maps were. We're going back to Democrat. In 2000, you had a Republican governor and Democratic legislature. They decided we don't want this to go to the courts. So they did a compromise with the Republicans, and they said, let's draw the line so nobody loses. Democrats will win our existing Democratic seats, Republicans will win your seats. It's called a bipartisan gerrymandering. People who lost it, people who want competitive elections. So effectively, 265 elections, there are only 2 party hand changes in that whole decade because of that, the way they drew those lines. Schwarzenegger became governor and was incensed by this, and he said there's more turnover in the Habsburg monarchy than there is in California's politics because of how these lines are made. He made a promise that he was going to terminate tyranny. So Schwarzenegger teams up with big government groups like Common Cause, Legal and Voters, and the Republican Party, and they put forward Proposition 11. It's going to take this out of the hands of the legislature and going to create an independent commission that is party neutral to draw just the state legislature lines, state assembly and state senate. Findings really kind of express the principle. And then allowing politicians to draw their own districts is a conflict of interest that harms voters. So we're going to create a commission, take it out of the hands of the politicians. The measure squeaks by for the 51% vote. The legislature, having its power stripped, decides they want to get it back. So they put a measure on the ballot to repeal the commission, giving them back the power. And so the proponents grovel out and counters by saying, oh, well, then we're going to extend the power of the commission to cover Congress as well. So now the voters have 2 dueling measures. And ultimately, voters reject the legislature's measure and pass the extension. So now the commission covers Congress as well, which is what Prop 50 ends up being all about. CRC formed in 2011, and the last 2 election cycles, all those lines have been drawn by an independent commission. That takes us to today, which is Prop 50, where you're being asked to temporarily eliminate the maps drawn by the commission, just as to those congressional maps. Well, then I'll turn it over by my background to my colleagues, talk a little bit more about the status quo of Prop 51.
Thank you. So one thing I did want to mention is just a little point on the way that these propositions work. So the reason why the legislature needed to bring the proposition to try to repeal Prop 11 and why the voters needed to then bring an additional proposition is that once we pass things by the initiative process, we cannot undo them. The legislature cannot undo them without going back through a vote of the people. So as a general matter, unless the initiative itself provides for an amendment clause and allows for the legislature to amend it, it needs to go back. So to repeal a thing that was put in place by the voters, you got to go back to the voters, which is what happened.
Can you go back to the previous slide for a moment? You're talking about that right there?
I'm talking about Prop 27 and Prop 20 and why the legislature had to put Prop 27 on the ballot to try to repeal.
Yeah.
Rather than just doing it, right? Rather than the legislature just saying, we don't like this, we're gonna change it. They can't without a vote of the people, okay? Which is also in part why we are here at Prop 50, because all of this, all of our independent redistricting has been put in place through propositions. So to remove it or to change it, we need to go back to the ballot. We need to go back to the people. Okay, so that's an important kind of piece of why we're here. So let's talk a little bit about what Prop 11 did, and then by extension, Prop 20, when the people passed the Independent Redistricting Commission for the congressional districts. So first of all, there are process protections that were put into place by Proposition 11. And those are, there was a public application process. There is a public application process before each new census and each new redistricting. There is a public application process where people can apply to be on the Citizens Redistricting Commission. There are very strict qualifications. You can't have any, you yourself can't have been an elected official. You can't have members of your family. There are very strict criteria for who can apply to be a member of the Independent Redistricting Commission. And there's a requirement that there be balance. So in order to be chosen, there's going to be a maximum of 5 people who are registered as Democrats, 5 registered as Republicans, and 4 registered as no party preference. So there is built-in requirement of not only bipartisanship, because there's also a requirement that some people be registered as no party preference. So there's actually, that's more than bi, right? Tripartisanship. Okay. There also are transparency protections. So the Independent Redistricting Commission holds public hearings. In 2020, they apparently held 196 public hearings. They go around the state. They say, come see the work we're doing. We want to hear from the public about concerns, about the maps that we're proposing, about whether your district is, adequately configured to represent the interests of the people within it. And they have a requirement of no ex parte communication. So anyone who wants to talk to any of the commissioners about the process needs to go to a public hearing. There's no like, I can't call my friend on the commission, if I had one, to speak outside of the transparent public hearings. And then there's redistricting criteria. So it's very clear that there is a prohibition on partisan gerrymandering. There are criteria that are ranked, and the focus is on keeping communities whole. So it tells this the proposition itself tells the commissioners how to prioritize the criteria for crafting the districts. Keep cities and counties intact as much as possible. Keep the lines contiguous. Don't be jumping over bodies of water or geographic boundaries, right? But the focus is on keeping communities whole. And so that is another protection that's in place with respect to Proposition 11. So the overall assessment. And of course, since we've had this in place now for 2 different cycles, we've had commentary after each of these cycles from independent groups. These are reports from the League of Women Voters, first one in 2011, which basically say it's been really successful. It's been nonpartisan and transparent. It's working pretty well. Again, Fair Maps in the state of California report that came in 2021 after the 2020 process was played out, talked about the fact that it has been massively more participatory and inclusive and transparent, and it is working pretty well at drawing districts that reflect and empower the communities that they're representing. So on the whole, we have had a pretty successful go at this process of doing redistricting in a nonpartisan way outside of the legislature's control. That's where we are now. On the other hand, we have this national stage where for a little while, it looked like we were having some other states move along with us to be having independent redistricting commissions. You can see the blue are the states that have commissions drawing their district lines. The gold are the legislature dominant states, and the green are a couple of hybrid states. Obviously, well, you can see the map, right? The states where legislatures are in control of the districting process vastly outnumber the ones where commissions are in control. And primarily, with a few exceptions of Michigan and New York and a few exceptions on the East Coast, primarily we're Western states where we have commissions at play that are doing the districting. And we don't have a whole lot of states moving towards a commission-based districting at this point. And there's no federal reform in sight. In fact, the Freedom to Vote Act, which was introduced in Congress in 2022, and the Republican Party filibustered it in the Senate, did not pass, would have mandated independent commissions in every state. But that did not happen, is not likely to happen. There is no path at this point forward for that. So where does that bring us? That brings us to the chaos that's happening today with the redistricting wars of 2025. And excuse me, the Trump administration openly advocating for Texas in particular, but other states as well, to do a mid-cycle redistrict. We're in 2025. This is not the time when we would normally be seeing redistricting happening. And there has been a call by the White House for Republican states that have control of their legislative redistricting to do mid-cycle redistricts to in advance of the 2026 election to try to create more seats that will be safe for Republican candidates. Okay. It's been a very transparent campaign. It has been reported on extensively. Okay, that's a lovely picture. So in August of 2025, Texas answered the call, did a redistricting, that will result in 5 additional safe Republican seats for Congress in Texas. Missouri in September followed up and did a redrawing of its lines to add at least one additional safe Republican seat. And in progress, just yesterday, North Carolina's Senate passed a new map that would add an additional Republican seat. And it is expected to pass the other house of the North Carolina legislature as well. So Gavin Newsom in an effort to stand up to what's going on with respect to the call for additional Republican seats to be drawn in mid-cycle redistricting, Gavin Newsom has advanced and presented Californians with Prop 50. Prop 50 is the Democratic response at this point to say, if we're going to have a situation where openly states that are Republican controlled are changing their maps mid-district, then a Democratic controlled state can do the same. And the proposed map that has now been put before the voters as Proposition 50 would add 5 safe Democratic districts for Congress in California. Okay, so that is what it is doing. There are other states that are considering doing redistricting. You can see the list of them, how they would play out. It's really anybody's guess at this point, right? Because it's kind of an open season for redistricting, for mid-cycle redistricting. The other thing that has happened that I just want to touch on very briefly is that a week ago today, last Wednesday, I think it was, I'm trying to remember, I was listening to the arguments and then went to class and I remember feeling sad. So it was a day I teach that this happened. But we had argued in the Supreme Court, the Louisiana versus Calais case. And that case is about Section 2 of the Voting Rights Act. And Section 2 of the Voting Rights Act is a protection for ensuring that minority votes are not diluted, right? Section 2 is an important tool that has been upheld as recently as 3 years ago by the Supreme Court as an appropriate act by Congress to say that where you have a situation where states are drawing district lines in ways that would dilute the voting power of certain groups of people, that they can bring an action, and if they can prove that they have sufficient numbers and vote together enough of the time to create a politically viable district that would elect a candidate of their choosing. And if they can show that the white majority in that state votes as a block and would vote to disallow that group from being able to achieve the representative of their choosing, that creates at least a threshold claim that can be brought forward to prove that drawing lines to either crack or pack, as Professor Heidorn explained, that drawing lines that either crack or pack groups of minority voters are illegal, okay? So Calais is a case where the justices, at least from the oral arguments, seem likely to say that any consideration of race in redistricting, whether it is to remedy discrimination or not, is not permissible. And it looks like that Section 2 may be, well, we'll just see. The decision is not out, but let's just say that the arguments didn't sound super hopeful for Section 2's continued viability. If that happens, there are quite a few congressional districts that have been drawn across the country and in different states with Section 2 in mind, because they thought they were complying with Section 2 of the Voting Rights Act. Some people have speculated that there are between 15 and 20 such districts that, if it is no longer required to create districts in such a way as to ensure power for certain groups of people, it very well may be that those states, if they haven't already, decide that they will do a midterm redistricting as well, to eliminate the district that they created pursuant to Section 2 of the Voting Rights Act. So I think that could actually spur on another round of redrawing of lines based on the decision in Calais, and we'll see how quickly it comes out. Okay, what does Prop 50 do? Let's get to the nuts and bolts of it. It adds as section 4 to Article 21 of the California Constitution. It calls first on Congress to pass legislation and to propose a constitutional amendment to require fair, independent, and nonpartisan redistricting commissions nationwide. So basically, it is a call to Congress to do what the 2022 Freedom to Vote Act would have done. Okay, that's the first thing it does. Second, it temporarily adopts a new US House map and district lines that were passed by the legislature as AB 604. Okay, so the legislature passed maps. The proposition says adopt that map that was done by AB 604. And then it reverts congressional map drawing back to the Citizens Redistricting Commission in 2031. So after the next census, it says go forward, do the commission. Once we have the census in 2030, we're going to go right back to our commission. The other thing it does not do is it does not alter the Senate or Assembly maps or the Board of Equalization, which the commission also draws lines for. So state district lines would still be drawn as usual by the Independent Redistricting Commission. Okay, the only thing it does is a temporary suspension and says use the maps in AB 604 for the next two elections, basically 26 and 28, maybe 2030, three elections. So these are the lines that AB 604 draws. The analysis says that currently for congressional districts, we have 43 Democratic districts and 9 Republicans. Okay, the and this map is going to seem fuzzy for a minute, so just bear with me. Under Prop 50, there would be 47 Democratic seats and 5 Republican safe seats. Now that is 9 minus 5 is 4, not 5. I do understand that. Okay. Lawyer, but also basic math. Okay. So the reason for that is there is currently a district that, while Trump won the district, and so it is kind of a Republican, would be considered a Republican seat. The congressional seat is being held by a Democrat right now, but it is not a democratically safe seat. It is a very, very purple seat, and that one, even though it is currently being held by a Democrat, would become a safe Democratic seat under this line. So that's why the +5 Dem seats, it means +5 safe Democratic seats. And we're not worrying about that one that was really being considered a Republican seat that just happened to be won by a Democrat. Okay. So our current plan on the Princeton gerrymandering project's partisan fairness score gets a B, and this new plan would get an F. It is not fair. It's not good in that normative, abstract way. But the question, also, you're going to do 30. I was going into the 30,000-foot view, and I told Professor Heidorn he could do that. So I won't say it. We'll hold off. I want to give you a couple of additional pieces of information about 604. AB 604 was passed as urgency legislation, and Proposition 50 will take effect immediately upon passage. These are just like additional things that you should be aware of that this legislation and initiative do. The law does contain a severability clause. So if any part of it were deemed invalid, if for say the court said you can't do a sort of directing Congress to do things part, that part is not valid. If that were the whatever is left would be viewed as probably being severable because the proposition itself says the voters intend for all the other parts to take effect. We expect that the voters are aware of what the proposition says. So there is this severability clause. And then the law also provides for exclusive jurisdiction in the California Supreme Court for any challenges. So this, if it were to be challenged right after it passed, would go straight to the California Supreme Court. And that matters because obviously time is of the essence here in terms of 2026 elections. And so I think that's an important little piece that was added in here. Okay, so pro and con. The yes on 50 people are saying, look, the Democrats are hoping that this will create 5 new secure Democratic congressional seats to counterbalance the gains that of Republican seats that have been achieved by Texas with what they just did. And now Missouri too, and now North Carolina too. It's not going to totally counterbalance all of it because there's much more going on in terms of the legislature driven redistricting that's happening in predominantly Republican states. And the yes people also say this is a check on the power of President Trump, right? This is saying, hey, no, you can't go calling for rigging of elections with no response. That's the yes side. The no side is taking the position that these proposed district lines are going to dilute the votes of farmers and rural Californians by placing them in districts with urban and coastal voters. This is cracking the interests of the rural Californians. This is doing harm in ways that are not appropriate. And ultimately, the no side says rigging elections is not the right way to operate, no matter who's doing it. As Bradley said in class earlier today to me, 2 wrongs don't make a right. That is the basic no position. 2 wrongs don't make a right. So those are kind of the positions that have been set forth. You want to do 30,000 foot? Why don't we both do 30,000 foot and then we can take questions from you.
Yeah, I'll just add a few others on the 30,000 foot level. I think as a voter is considering this, there are probably a few things you want to think through. First, do you believe that redistricting should be nonpartisan, or do you think it should be partisan? So there's a normative claim behind the commission where if you don't even agree with it from the initial standpoint that you should have commissions, this is a very easy vote for you because you want it to go back to the legislature. But if you believe in nonpartisan redistricting, then you have, I think, a few separate challenges for you. There's kind of, okay, what about the democratic aspect within California? What about the fairness of representation within California? How much do you value that? Or how much do you raise your lens even more and look at it from a fairness at a national level? And there are kind of competing tensions. Like this could be done in a way that is partisan in California and unfair in California, but by balancing out unfairness in other states, perhaps we get to a more fair overall standpoint. So I think that's kind of, you got to choose your lens. Is the California lens, fairness of representation internally for California more important to you, or is there kind of a national lens that you want to care about? I'd also
Can I add on to that one
Yeah.
before you? So, and I do think that it's for some of that, a little bit of looking at like, what are we talking about? So Prop 50 is narrowly focused on the congressional seats. And so if you are looking at it in terms of like, what is the body that we're trying to place the overlay of fairness upon, then we're talking about a national government. This is what the yes people would say, right? They'd say, we haven't touched the state. We haven't touched the state Senate and the assembly lines. We are leaving those to the redistricting commission. And so I think that on the other hand, there are individual people in all of these districts that will or will not be more or less likely to represent representatives who are of their choosing, representatives who care about the interests of their community. Go ahead.
I thought that was great. Yeah, the overlay of fairness and what level of generality you want to view fairness, I think, is an important consideration. I think the last thing that could be an interesting consideration for a voter is where do you predict the future to be and what gets you to the better version of that future. So a few things I would point out that could be considerations. You saw how the national reform at the national level has stalled. You also saw how state by state reform has effectively stalled, with mainly Western states and Democratic states adopting commissions, but not Republican states. Which one leads to maybe a more better result in the future, or does it have no effect that could affect your thinking? Does California joining partisan redistricting lead to more of a national solution where people feel, oh, it's better to solve this nationally, or does it lead to just more people going away from the independent model that looked like it was gaining traction? So does it cause us to go even further into partisan redistricting, or does it escalate the war so much that everyone agrees to put down their weapons? That could be kind of future thinking. And then the last thing is this measure expires in 2031. So the commission takes over our congressional lines again after the 2030 census. I think another thing you could think through is, once this power has been given to the legislature, is there going to be an effort to extend it? Is that good or is that bad? I would suspect there will probably be an effort to extend it further, and so that could play into your thinking.
Okay, questions. We left 12 minutes. That wasn't as many as we hoped, but. Are there questions in the chat, Jim?
Not right now.
Not right now. Okay. Any questions here? Jasmine?
I think often right now, I mean, maybe more in recent elections, people have been more involved and wanting to vote, but there is still a history of people just feeling that the vote doesn't count, even without like things like this being more apparent. So how do you think we can go about, maybe, I think a lot of people, like, I've seen all of the ads for this bill, whether this is a yes or a no vote, educate people about kind of this idea of gerrymandering, or idea of voting if this does pass. Kind of, as a voter, how can I feel that my vote even counts if I know for a fact it's already a rigged like system? Is maybe how I think that's kind of, honestly, kind of, I'm from Kern County also, so like I'm in that rural area, and I think sometimes people don't realize the federal impact that is on a lot of those farmers and those industries. So I think sometimes those people feel like their vote doesn't count, and it's like, okay, well, what's the point now? I don't know if that's a question, but.
Yeah, I think that's a really important observation. And I would call that an observation and not a question. Like, how can we make people feel like their vote counts when a lot of the system is rigged in a way where it doesn't? And I think that, you know, we have this question at all sorts of levels in the election law context as well, right? If we really start thinking about the ways in which we as Californians have only 2 senators, and guess who else has 2 senators? New Hampshire. Like, really not that fair, right? Like, there's really a lot of unfairness baked in already to the system at the national level, especially. And so I do think that it's very hard. And I think there are questions about, how do we engage the public to really understand that it made a big difference that the Supreme Court could not come up with a justiciable standard to stop the kind of gerrymandering that was escalating. And now we're here. And the one thing I wanted to add about the Alexander case, where the court has said that there is still this ability to bring a claim for racial gerrymandering. It says that, but they had a 9-day trial with like multiple expert witnesses that said these maps are racially discriminatory. And Justice Alito said, I don't think the experts were right. I think this was a partisan gerrymander, not a racial one, and it's okay, and we can't do anything about partisan gerrymandering. So I would say, as a practical matter, based on the current situation, we don't really even have an ability to bring claims that would challenge racial gerrymandering. Because if the presumption is that the legislature acted in good faith, which is what Justice Alito said, then, and it is not rebuttable when you have multiple experts in a 9-day trial, I don't know that we actually have any ability to stop the either partisan or racial gerrymandering currently under the law. right? So now then, how do we change the law? We change the law by having Congress take action. That's how we change the law. If the courts won't save us, which I don't think they will. Sorry. Will they save us? No. Then we need to have Congress. And how do we get people to vote? It's to instill in them this idea that if we don't vote, if we don't have representatives who will do the work that we have put them into office to do, then democracy, sorry, I'm getting very depressing now. Sorry, next question.
Can I piggyback on that just with a few things? I think you're right, it is a recipe for cynicism because these were rigged precisely to make it so that it didn't matter, and that's very hard to fight. But if you totally give in to that cynicism, it only gets worse. So I think one of the things is to encourage people to continue participating, even if you can't win at Congress. There are other lines that are more competitive or not rigged, where you can make a difference, and different levels of government have different attempts or ways to contradict this problem. I think for you all as attorneys, it also, whenever we enter moments of chaos, there's also opportunity for new thinking, and that can sometimes be exciting or open up new avenues. That can be new legal theories for how potentially this could be addressed. We now know Equal Protection Clause, First Amendment isn't going to do it. Is there another side of the Constitution, the guarantee of a Republican form of government, maybe, that you could address it? But then there's also policy, and I think here too, you get into interesting realms, because currently we have what are called single member districts. And whenever you have a single member district, a huge minority is not going to get representation. We have a two-party system. An overwhelming Democrat or Republican district would be one that voted 60-40, for example. That still means 40% of people aren't going to get any representation because you can only have one person. So other countries have moved to proportional representation, and this could be the moment where maybe we start thinking about other systems. Proportional representation has other downsides, but it's immune to gerrymandering. So this could be a little bit of a spark to say maybe we don't think single member districts are reform, and we should start looking into other countries for
Maybe we start thinking, I think this is such a good point. Ranked choice voting can help, right? There's lots of different creative solutions that might help, that might make things different. John Mark had his hand up, and then you, Teddy.
Yeah, I just had a brief question about this, like the acceleration disposition. If California, if we go ahead and do this thing, and then Congress gets upset and says, oh, we gotta stop this partisan, wouldn't that, sorry, doesn't that rely on the end of the accelerationist period, where everyone's doing the cracking and packing? Doesn't that rely on that, like flipping, like, doesn't that rely on that, I guess, giving Democrats more control in Congress for this particular, like, and do we know that would happen? If we were to push this accelerationist gas pedal, right, to try to get Congress to do something about partisan redistricting, do we know that it would act? Does that make sense? Does that question? Sorry.
So you're kind of asking, so if California decides to get rid of its commission for congressional lines, and that kind of one-ups the ante, what would be the theory for why that would cause Congress to kick in the gear and solve the problem by mandating commissions everywhere? This is prognostication. I think everyone could have their different vision of what the path would be. I don't think it would happen in the short term. I think you're right. I think everyone would have to weaponize, and then you'd have to have enough weaponization that people decide it's no longer in their interest. I think an example of where it's failed, but was maybe the model, is a Republican who's about to lose his seat proposed a bill to ban mid-cycle redistricting and undo what Texas has done. Now, that's probably not going to have much sway because the Republican president is asking for this mid-cycle redistricting. But you could see potentially a world where if all the Democratic states weaponize too, and all these Republican members of Congress are going to lose their seats, even if Republicans might still hypothetically retain the majority in this new version, you might have majority of all Democrats who want to get off the escalator, and then those 40 Republicans are about to lose their seats because the Democrats might cross party. So that could hypothetically happen. I think it's unlikely in the short term, but maybe in the long term. The other version though, is maybe it doesn't call for reform at all, but it has a race to the bottom where suddenly every state has strict lines and there's very little competition left.
Teddy?
Yeah, so my question kind of builds on that. So my question is really about big purple states like Pennsylvania or like Michigan or Wisconsin. So I'm gonna circle back to that in just a sec. Because I've heard the argument that one reason to vote yes on Prop 50 is that California could have gotten more than 5 seats. They could have gotten 6 or 7 seats, and that they only decided to do 5 to just counter Texas. But now that there's these other states doing it, and they seem it's mostly red and blue. So I'm just wondering what would stop a big purple state like Pennsylvania from doing a redistricting and just totally flip the map just based on if this flip to the redistricting for red or blue.
I mean, that's kind of where we're heading, is that they can just do that. Now, part of the reason why you're seeing it more in Republican states is you usually need what's called a trifecta to be able to do it. So that means you need both houses of your legislature and you need the governor. I don't have the math with me, but you can look it up at Wikipedia. Like, Republicans have way more trifectas than Democrats do to start, so Democrats are at a disadvantage in fighting back. The other thing is that places with reform have been more likely to happen in Democratic states. So that's the Yes on 50 campaign is saying the Democratic states have disarmed, but the Republican states haven't. So hypothetically, what you're saying is entirely possible, and states that have trifectas are doing exactly that. But some of the other states where you aren't seeing movement, it's probably one of those reasons. They don't have a trifecta, or their constitution has a commission that prevents it. Actually, one other note on that I'm curious if you guys caught. Why do you think the Western states it's happened so much? Anyone have a guess why the West it's been so popular?
Well, I mean, there's sort of a populist tradition in the West that dates back to like the 1880s, 1890s that like sort of had this Roosevelt kind of, or like Teddy Roosevelt kind of conception of like, you know, participation in politics at the local level. And I think that sort of has bled into some of our process. I think the initiative process is a big example
Yes,
of that.
that's the answer right there.
Yeah.
So if you plot the map of who has the initiative process and who has commissions, it's not 1-to-1, but you'll see the clear overlap. So a lot of the commissions were done with the opposition of the legislature. California's commission, the legislature opposed Arizona, same thing. So the initiative process is doing in a certain sense what it's intended to do, which is we have the initiative process to get around the politicians when they think they're not represented.
Surprisingly, legislators like to have the power to draw their districts. And so in states that don't have the initiative process, you don't usually have an independent commission. Yeah,
So I didn't hear any conversation about turnout and how that affects voting. And I'm curious as to how the drop in turnout from the 2020 election to the 2024 election plays into this. And also want to just throw one more piece into the question that I've got is that it seems like at an overwhelming rate, every election that we've had since Trump won in any state has been rejecting those kind of policies. So I guess what I'm saying is I see an historically unpopular president trying to pass historically unpopular policies. And we haven't had like entire statewide elections to kind of reject that yet. And I'm wondering, really, is this necessary when you see his popularity down in like the 35 to 38% range? Can we just rely on the people to come turn out the vote to reject these policies?
in 2026.
It's 26 and 28, yeah, both.
I mean, I think each individual has to probably decide that question about what they think is going to happen for themselves. I mean, I think turnout in any off-cycle election is always very bleak. And I do think that, you know, one of the reasons the legislature passed a law now, I guess almost a decade ago, to say that all of our initiatives would be at general elections instead of primary elections was to try to ensure that when we have ballot measures on the ballot, that there would be sufficient turnout, that we really would be getting a sense of what the people want. And I do think there's a risk that this being thrown on in an off year as an additional election, it is unlikely to get the kind of turnout that you would hope for a decision of this magnitude. Like, I am personally concerned about that and the way of doing this. But in terms of kind of the normative question of like, can we trust people to come out in 2026? The problem is, I don't know the answer to that. I don't think anyone knows the answer to that. Maybe Nicolas.
I don't know the answer to that, but I do think your question raises some really good ones related to it. So for example, on turnout. Turnout can sometimes defeat a gerrymander, but it usually has to be pretty high. So remember when we talked about the data people have data going back 40 years of how people worked in precincts. So what they'd actually do is they'd say, okay, let's draw these maps at these certain concentrations and let's assume a wave election. So if we had a wave election with this percentage higher turnout for one party or the other, is that going to win them the seat or not? So gerrymanders are usually designed to be able to withstand wave election.
Wave proof.
Yeah. Now in Texas, to gain the 5 seats, they have to cut it a little thin. So some people are predicting it's what's called a dummy mander. That's when you gerrymander, but it backfires on you because you cut it a little too close. And so some people argue that was based on how Republicans did with Latinos in Texas when Trump was elected, and that may not repeat. So it's possible Texas's move will backfire. Another thing just on turnout though is there's a separate branch of literature that looks at competitive elections and turnout. And not surprisingly, more competitive elections leads to higher turnout. When people think the stakes are real, they're more likely to turn out. So one of the other downsides of gerrymandering and creating really safe seats is they're less competitive, so it tends to lead to lower turnout.
Interesting. All right, we're at time, but thank you all very much for coming.
You all